Aloha and welcome to Condo Insider. This is actually our inaugural show that we are going to be presenting on Think Tech Hawaii. You can see it every Thursday at 3 p.m. on Hawaii Tech, thinktechhawaii.com, and we hope you'll join us. When you think about it, 1 out of 3 residents in the state of Hawaii live in some form of a community association or an association. Maybe a condo, maybe a homeowner association, might be a planned unit development, or even a co-op. But each of those associations have legal obligations for both the owner and the board of directors to run their association properly. And so today, we're going to be talking about the basic foundations of an association. We hope this show will bring you education, discussion, and debate on the important issues facing our association each year. Today we have 2 really incredible guests on the show. We have Jane Sugimura, who is a long-standing condo advocate and current president of the Hawaii Council of Community Associations. And we have Richard Port, who's been a long-time advocate for condo associations. And for those who may recognize Richard, he used to be the chair of the Democratic Party here in Hawaii. So I won't ask you any questions about the Democratic primary. Anyway, Jane, how did you get into condo advocacy, and tell us a little bit about your background?
Well, I'm an attorney, and I got into condo advocacy by a good friend. His name is Milton Motoka, and he was part of the Hawaii Council, and he approached me. He recruited me, basically, because he needed somebody to testify at the legislature regarding condo issues. And unbeknownst to me at the time, they had a legislator who was my House representative, who said she didn't have a problem of leasehold in her area. And Milton knew I lived in Aiea. And so he recruited me for that purpose. And it was basically leasehold conversion that got me involved in, and that was back in the early 90s, and I've been involved ever since.
And how did you get involved, and he got you involved in Hawaii Council?
He got me involved in Hawaii Council, and so I served as a regular board member, and I was the treasurer at one point, and then I became president many years ago.
And how would you describe the purpose of HCCA and what their primary goals are?
Okay, what we look to as our primary goals is to educate board members and owners about their rights and obligations, in living in a condominium. And there are so many, issues that, are brought to our attention that, has kept us, relevant and active in trying to educate, our constituency. And we look at our constituency not only as board members, but owners, because they're members of the association. And so they're an integral part of what we consider to be our constituency. And so that's what we do. We educate, we advocate, we're in the legislature, we're at the city council, anywhere where, a condo issue may come up, and we try to advocate and educate our elected officials so that they will do things for the benefit of condo owners.
So anyone can join, a board member, an
Yes.
association, an owner, anyone can join, and anybody can attend the seminars you do regularly on the education format.
Yes, yes.
Our other guest is Richard Port, who I've known for a long time, who's a longtime condo advocate, and I know he lives in a condo. And tell us about how you got involved in condo advocacy.
Well, I moved into my condominium in 1974, and for about 6 years I didn't get involved in anything. And there was an issue had to do with storage, and I was on a committee that the board had formed to look into storage issues. And when it came time for the board to take up the matter, I asked if I could sit in on the meeting. And they said, oh no, only board members can sit in on board meetings. You can sit in on the annual meeting. So I went up to the legislature and I said, your meetings are open, shouldn't board meetings be open? And they said, well, that makes sense. And then the next year I found out that we were not able to get monthly financials, and absentee owners were not able to get information about the minutes of the meetings. So again, I went up and I advocated, and we've put in quite a few general laws that made sense in those times to bring some order, because most board members are fine, most presidents are fine, but on occasion there's somebody who kind of steps out of line, and if it's a big issue, we have to find out some ways, and we'll be talking about some of the ways that disputes can be handled.
And we're going to come back a little bit later in the show about owners' rights. And I want to talk about basically how a condominium is formed. But first, I'd like the audience to have a little bit of statistics. First of all, we should know that, as I said earlier, about 1/3 of the population lives in an association. That means 360,000 Hawaii residents live in 135,000 homes in nearly 2,000 community associations. And if you estimate the value of those board members, what they do, that's quite a bit of money that takes away those costs from government. And in that, those owners will pay about $400 million a year in maintenance fees and other assessments to support their community. And each year, about 13,000 residents or owners are elected to their condominium board of directors. So this is a big industry which has a big impact on Hawaii and the real estate community and the rest of it. So we're hoping our show will educate people on the obligations of owners, the obligations of board members, the issues facing our industry, and we hope they will even send in some questions if they have them. That being said, Jane, when does a condo become a condo? When does it get born? How does that legally happen that all of a sudden we have this issue, a condo?
Okay, what creates a condominium, and it's in the statute, and it's in the condominium statute, it's HRS chapter 514A and 514B now. 514A is for those condos that were built before 2006, and 514B is kind of regulates those condos that were built afterwards. But there's something called a declaration of, it used to be called the Declaration of Horizontal Property Regime, and now it's called a Declaration of Condominium Property Regime. And what that's like, what that is like, if you think about a corporation, when you create a corporation, you do articles of incorporation. When you create a condominium, you do the declarations and you record them with the state of Hawaii. And the declaration just says that there's this piece of land, identifies where the land is, how big it is, and then you describe the building. It's a 16-story building, a 26-story building, and how many units are in there? 300, 500, and is it 100, one bedroom, 200, two bedrooms, and then you describe the dimensions. You describe exactly what is going to be in that building. What are the common elements? What are the limited common elements? And how do you operate this building? And how do you manage the building? And how do people pay to support the administration and management of the building? That's all in the declaration. And that's what creates it. The minute that's prepared and filed with the state of Hawaii, a condominium is born.
Does that mean the developer can sell them at that time?
No. No, it just means that it's been born and they can start building it, but once they build it, they sell it, and then at some point, it reaches a number where you have people who are living in the building, and then the developer will turn it over to that group, and that forms the basis of an association. And then there are bylaws. There are bylaws, and the bylaws basically tell you how to operate on a day-to-day basis. It tells you who your directors are, what their authority is, and how they have to conduct meetings. I mean, do they have to conduct it once a year, or quarterly, or every month, and how many directors you need, how they're elected, how they're removed, and it basically says that it tells people that the board is the one who goes out and hires people to manage the building and the project, but ultimately the board is responsible for the management and operation of the condominium project.
And how does the public report fit into all of that?
The public report is a report that's prepared by the developer, and it's filed with the Real Estate Commission. And it is a public report. That's why it's called a public report. And it's available. You have to give it to every prospective person who comes to look at a condominium. And this is a brand new condominium. So if they're the first time on the market, if people are interested in buying it, they get, and what it is the summary of the declaration that got filed with the state of Hawaii, and the public report also now, under the new statute, it tells you what your maintenance fees are going to be. In the past, under the old rules, it kind of gave you a really rough estimate, so you really had no idea when you bought into a condo what your maintenance fees were going to be. But under this new law, I mean, the public report does give you, it's supposed to give you as close as they can practically put the information together what your monthly maintenance fees are going to be, so that when you buy into a building, you know, you have an expectation of what they're going to be, so that if it doesn't, if your actual expenses are above that, then you have a basis to really complain, because the report is supposed to tell you what those amounts are supposed to be.
Well, you kind of hit on a term, I think you said they govern themselves.
Yes.
So self-governance, let's just say it. Would you elaborate a little bit more about that means, because...
Well, self-government means that, that the entity, the association rules itself. And what this is when people buy into a condominium, it's like entering into a contract. It's as if, you and I had a contract to do something. And the contract in this case is a declaration. And when people buy into a condominium, they accept the declaration and the bylaws as their contract with the association. And so that sets out, what they can and cannot do, and it tells them how they can participate in the government by voting for their board members. And the board members are the ones who operate and manage the building. And if the homeowners are upset with how, with the operation of the building, they can complain to their board, and they should. They should complain to their board. And if that doesn't work, they can unelect those people or elect other people to take their places. And that's what self-governance is all about. That's the reason I think the legislature doesn't want to really get involved in regulating, these homeowner associations, because of the contract theory between the owners and the association. And that's what self-governance is all about.
Well, it's very interesting. We're going to take a short break to regroup here, and we'll be back with Richard and Jane in a couple of minutes, and we hope you're enjoying the show.
And I am the host of Business in Hawaii. Business in Hawaii is a show where we invite guests to come on and explain the secrets of their success for having a successful business in Hawaii. Contrary to popular belief, having a successful business in Hawaii is possible, and there are many examples of that. So please tune in on Thursdays at 2 o'clock, and you can catch us live on livestream.com for our Business in Hawaii show. You can also get the archives on hawaiitechhawaii.com, and we're also on YouTube and also on Oleo and OC16 occasionally. So please join us, find out the secrets of success, how to have a successful business, and I hope to see you on Thursdays.
Aloha, we're back to Condo Insider, where we're enjoying the conversation with Jane Sugimura and Richard Port on issues facing condo associations. And as I said, this is an inaugural show that we're trying to educate and debate and discuss the issues in this important industry. Let me just summarize what Jane said before the break. A condo is formed when the declaration is filed with the Bureau of Conveyances. Doesn't mean the developer can sell it, but the condo exists.
Yes.
The declaration is kind of the primary document, almost like the Constitution. Defines kind of what we own and what we owe. What is the apartment? What is the common elements? How much we owe for maintenance fees? The declaration establishes governance, which is the bylaws, which will determine how directors are elected, term limits, all the various issues, what authority the board has with respect to it. And boards in most cases have the ability to set up everyday rules, which would be like house rules, to make your daily living there a pleasurable experience. And so that's kind of how I would summarize what you said. But I think what is often forgot is that when you look at condos in Hawaii, we think of 514A and 514B, we always think of residential condos. The high-rise, the low-rise, the cluster home, sometimes you have single-family homes. But you know, we have mixed-use condos, senior living condos, assisted living condos, storage condos, parking condos, spatial condos. So when you look at condo governance and condo laws, not one size fits all, because a senior living association may have special requirements for government management where a parking condo wouldn't have that. So when we look at our own internal issues as an owner or a board member, we need to be very cognizant of our documents and what authority we have and what our purpose is with respect to managing an association.
I agree, yeah.
Yeah, and so Richard, you know, we were talking kind of about the bylaws and declaration. What is your take on some of that?
Well, just to kind of unwrap the lettuce a little bit more, bylaws can be, well, first of all, when a person buys into a condominium, they get those documents that were discussed, you know, the declaration, the bylaws, house rules, unless it's a brand new building, might not have a house rules immediately, but sure, there will be house rules. So a person really, who's buying, really needs to look at the bylaws. And for example, the bylaws may say no pets. And if a person has a pet, they may want to be very careful on, you know, I mean, there's other kinds of things that are involved in that, comfort animals and so forth. But just anybody buying into a condo must read the bylaws and the house rules. And the bylaws can be amended, but it takes a super majority to do that. I think the current figure now is 65 or 67% to amend your bylaws. And that has to be done by the total membership. So if there was a case in the building I live in where originally pets were allowed, and believe it or not, at that time, I think the figure was 75%. 75% of the owners voted that the animals that were there were grandfathered in, but there could be no new animals. That was later changed. We might get to that later, but that was changed so that the owner was grandfathered in. But in any event, bylaws can be changed. House rules, there might be house rules. There definitely will be something having to do with no smoking in the inside of the building or within so many feet of the building. So house rules are also very important, and people have to, there's a kind, when you move into a condo, there are some benefits. For example, you don't have to deal principally with maintenance issues. Wonderful if you're elderly or even not elderly, but you're busy, you don't want to be dealing with maintenance issues. But you also have neighbors, and you have to follow the rules as they have been formed. Otherwise, you have to go to the board with respect to the house rules to make changes to the house rules. That's, again, peeling a little bit away of the lettuce. When you start getting into this, you need to consider a lot of things.
And for those watching, you know, there's two basic condominium laws, HRS 514A and 514B. 514A requires a 75% amendment to the declaration and a 65% amendment to the bylaws. With a simple majority of all the owners, they can opt into B. At that point in time, it becomes 67% for the bylaws and 67% for the declaration. Mm-hmm. And that's kind of how it stands today. What's important to emphasize is in what you said, is that vote is not just those attending the meeting, but it's of the entire ownership of the association. Right. So a person not attending or not voting is almost like a no vote. You didn't get the affirmative support you need to amend the bylaws and the declaration. Right. And so those are kind of the governing documents and almost like our Constitution, and that's why it's so difficult to change those out. Right. But what's interesting about this association living, in my perspective, you look at a board, they certainly have an obligation to maintain the common elements and create a nice living experience for the people who live there, including the tenants. Mm. But they're not really government. They have to comply with all the federal and state laws and everything else we do. Mm. But at the same time, owners get excited about their home. I mean, they're going to obviously get excited about where they live. Can you discuss some of the owners' rights? Because because it's almost like the Sunshine Law, not quite the same, not quite as apparent. Can we talk about what owners' rights are living in an association, and what kind of things they're entitled to, and we can talk about some of the disputes that arise
Sure,
as we go through this?
absolutely. First and most important, they are able to vote for their directors. They can do that and participate in actually wanting, if they want to be a director, they can submit a statement once a year when the election is coming up. So if board members are running for re-election, others who have not been on the board before can publish a one-page statement to all owners in that condominium, saying that they're interested in giving their experience, background, and so forth. The owners have the right to get monthly financial statements. They have the right to get to see the past minutes, even if they're an absentee owner. A lot of condominiums nowadays are beginning to put them on a website, which makes it much easier than it used to be. They would not. They can come to the meeting and speak. They're allowed to speak. Usually, a lot of boards have forums before, but they can also speak at the meeting on an issue if they have some expertise or reason for wanting to speak on an issue. They can do that. So there's a lot of rights now. Some of these had to be, we talked about self-governance, and I think the legislature would like to be hands-off on what you referred to as basically private entities. But in some cases, the legislature has had to step in. For example, the two examples I gave early, at one time, owners couldn't attend board meetings. Another time, owners were not able to get meeting minutes. Whereas they would prefer not to get involved, and frankly, if boards do the right thing, the government doesn't want to get involved and won't get involved. But occasionally it happens that something comes up, and I could give an example if you like. An example like this. Meeting minutes have to be available, but the contents of the meeting minutes can become a question. For example, I know of a condominium that had well over $1 million in renovation of their lobbies. And as I would expect, and I think all of us would expect, there had to be change orders along the way. Well, a lot of I think there were $250,000 worth of change orders. Only 120,000 were recorded in the minutes. So, it's a question of, normally today, because of technology, some issues that come up 2 or 3 days after a monthly meeting, they have to be emailed around, and even a decision may be made, but then it should be ratified in the following meeting. And the example I gave, only some of the changes were explained and ratified in the minutes. So that's the kind of thing that happens.
Well, I think, and I know you and Jane were strong advocates of some of these owner rights issues, and I thank you for that, because it's a fundamental issue that the owner owns that investment, and they should have transparency within reason to what the board is deciding, where your money is spent, what's going on. There's always going to be some exception, like there being a lawsuit or a personnel issue that you have to handle to protect the association in private. But the key word to me has always been transparency.
Right.
Make sure the owners know what's going on, they have a right to see the documents and be able to deal with those issues. But it's just a real short review on my part of some of the owners' rights. Is number one, board meetings have to be posted at the project. So owners have a right to know when a board meeting is. Number two, they have a right to participate in that board meeting. That's to say, the law is very specific. They have the right to participate in the deliberations. So having an owners forum in the beginning and then saying we're not letting owners speak anymore would be contrary to the law. Right. And frankly, I don't know why a board would want to do that, because you want to have your ownership base engaged in the issues of the association. Recognizing you could have an owner who just doesn't want to yield the floor, And then boards have a right to stop the debate after
Yeah.
some period of time to do that.
Absolutely.
And Richard, you know, there is a provision in the statute that allows the board to stop any discussion. The board can take a vote, and with a 2/3 majority, they can eliminate any discussion. And I think that the reason that is in the statute is basically to allow the board to control any type of disruptive behavior that occurs. And we've heard stories about boards, you know, taking the 2/3 vote at the beginning of the meeting. Now, that's clearly wrong. And, you know, that's not what was contemplated, but it happens. And because when that law was passed, I don't think that was contemplated. It was passed because this way the boards would have a tool that they could use to control their meetings if somebody became disruptive or somebody got up and started talking and wouldn't shut up, you know, and sit down and let somebody else speak. And so I think if there are people out there, owners who live in a building, who have boards who do that, they need to, you know, write a letter to their board and complain about it. And maybe at the annual meeting, you know, if it doesn't stop, to elect board members who are not going to do that. But, you know, I think the owners in that situation, you know, have an obligation, even though they're not the decision makers, they need to complain. There's nothing wrong with complaining, and, you know, write a letter to the board, and I sit on board, Richard sits on a board, and we get letters and emails, and they stop us in the hallway and complain, and that's what, you know, board members are for.
Well, being a 25-year industry veteran of going to board meetings, I would tell you, for the most part, people are treated respectfully and there's honest debate and dialogue.
Yeah.
But I've also been to meetings where we've had 7 lawyers, and ultimately the police had to be called, and it got to be very disorderly.
Yeah.
And that's why you have Robert's Rules of Order, in
Right.
theory, to try to control some honest debate on the substantive issue before the association. It's not a perfect world.
Right.
But in addition to what I just mentioned about participating in board meetings, when it comes to the annual meeting, they have a right to solicit proxies. They have a right to vote for the director, any proposed amendments to the governing document. They also have the ability, which we're going to talk about a little more detail, is the right to see certain documents of the association. And I know when I was talking with the Regulated Industry Complaint Office, that the #1 complaint on the condo side, because they obviously regulate the barbers and all the other licensees in Hawaii, was failure to give documents that the homeowner has requested. It's the #1 complaint. The #2 complaint actually was owners not being able to speak at board meetings. That people pass these improper rules to keep people from being able to be heard. And,
Yeah.
you know, I think one of the common things is that people should have a right to be heard and transparency. And then there's within the new statute, particularly last year, Act 187, a new form of dispute resolution came about, which is funded from the Continuing Education Fund of the Real Estate Commission, which allows a forum at nominal cost, which I'll discuss shortly, to have a hearing. But what you have to remember that the purpose of that evaluative mediation program is disputes between owners and boards or associations regarding declaration, bylaws, and house rules. It's not between a vendor and I don't like the painting contract or whatever. The purpose of that fund and that increase in the fee we faced last year was to support at the Real Estate Commission's Education Fund evaluative mediation, so the owner who doesn't have the resources that a board does has a way to be heard and have an impartial, usually a retired judge, deal with the issues with respect to that. So I think it's very important that boards understand that they have an obligation to be transparent with owners, recognizing owners have to understand there will be certain things that they're not entitled to. And so it's all part of the process.
Maybe we should give one example of documents that an owner might not be entitled to. Might not be entitled to bids before a contract has been signed.
And you've picked my favorite topic. So we're going to take another break for a minute to get ourselves organized here. We hope you're enjoying the discussion about Condo Insider and condo living, and we'll be back in just a moment.
Aloha, I'm Kaui Lucas, host of Hawaii is My Mainland, here on Think Tech Hawaii every Friday at 3 p.m. We address issues of importance for those of us who live here on the most isolated landmass on the planet. Please come join me Fridays at 3 p.m. Mahalo.
Okay, I'm Jay Fidel, that's Ray Starling. We co-host a show called Hawaii, the State of Clean Energy, every Wednesday, 4 to 5 p.m. It's really interesting. You know, Ray has a way of unzipping these guys. He asks them these questions and all this stuff tumbles out, and we find out stuff we would never know about without Ray's questions. Thank you, Ray.
You're welcome, Jay. I'm very pleased to be your Ed McMahon every Wednesday at 4 o'clock here on the internet. So you can join us and see what's happening in the energy world, and there is a lot going on. So join us every Wednesday at 4 o'clock.
Yeah, come around, be energized right here on Think Tech. Aloha.
Well, welcome back to Condo Insider, the new show talking about association living and the rights and responsibilities of both owners and board members. We're very privileged to have two of the great pioneers in Hawaii on condo advocacy, Jane Sugimura and Richard Port, who I've known, even though I'm only 19 years old, I've known longer than that, you know, but who are really sharing with us some of the issues. But before we took the break, we were talking about owners' rights. And owners have certain rights under the statute of notice of meetings, attending meetings, speaking at meetings, voting for their board members, voting for amendments to the declaration and bylaws, whatever it may be. But the one we didn't get to, we said we're going to get to now, is reviewing association documents and dispute resolution. Let's begin with reviewing association documents. The statute is fundamentally clear that owners are entitled to see the financial statement, to check register, the ledgers and journals. They're entitled to see all contracts, means the management contract. It would mean an employment contract with the general manager, recognizing that certain pure privacy information can always be redacted. And so, as I said, you know, the real estate industry complaint office, our number one issue is governing documents, or not governing documents, but documents in general, people, associations or management companies not wanting to provide them. And the catch-all to this is there's a little phrase in the law that says, and other documents. And so I know from my perspective, we've had owners request a copy of the signature card for opening a bank account. Mm-hmm. And in today's world, you know, you can steal signatures and you can steal bank accounts, and you can sometimes do bad things if you have bad intent. You know, you have issues of, for example, I want to see the gardener's personnel file. Mm-hmm. Well, you know, we're a class protected state, and you could have a gardener who maybe prior had a domestic violence violation, and if that owner got that information and went to social media, would create huge amounts of liability for an association. So it's not quite a crystal clear thing, in my view, what documents owners can get and what documents they can't get. Common sense might say that, but I'm not sure we all have common sense. What are your comments and your experience, both Richard and Jane, on this?
Why don't you start?
Well, you know, usually when somebody, and you know, and I think in most instances when the owners request a document, it's something very specific, and it has to deal with a specific issue. And I think it's done in good faith because, you know, they want to know, you guys the board did something. Can I see the board minutes where that vote was taken? And that's a legitimate question. And but I can remember an owner and asking the board to document a series of decisions that went back almost 15 years, and unfortunately, our association had minutes that went back 20 years, and so we and the owner was willing to pay, and we actually got an estimate from Hawaiiana, who was our managing agent, as to what it would cost to have somebody go through 15 years of board minutes to actually find the minutes that responded to the homeowner's question. And the homeowner paid several hundreds of dollars. But, you know, so yes, you know, sometimes, you know, to me that was really extreme because most people wouldn't pay, you know, to go back and have somebody hunt through 15 years. But it, you know, to me, if it's a specific question, and you have, by the way, we adopted a purging policy, so we don't have records that go back beyond seven years now because of that incident.
Not even minutes?
No, not even minutes. We just, everything is, we don't keep anything more than 7 years unless we have to for tax purposes. But, you know, there are people who will, you know, just because they're mad at the board or It's just unfathomable. They will ask for bank statements for 10 years, and it's like, why? Why do you want, and I guess if you want it and we have it, and you want to pay somebody to go and search for it and pay the copying charges, I guess, we would turn them over. But, they don't understand. I mean, they think that, I'm going to get back at that association. I'm going to make them do all this work. They're going to pay for it. And, so sometimes you get these requests that, you just, it's just crazy. You just don't know why they're asking for documents. But, they're entitled to it. And so I guess, what we have done every time, my boards have gotten it, is to try to address it. And usually, if it's something that requires a lot of documentation or going back several years, when we give them the estimate of what it's going to cost for somebody to actually do the search, they will back off. But we'll say, if you want something for the last 12 months, that's pretty easy.
Yeah.
And now we have our board minutes all on the website. I think it goes back 2 or 3 years.
Yeah.
So minutes are on the website. If you want your bylaws and declarations and house rules, you have to pay, so much per page for them, and we'll give them to you because you got them when you bought into your unit. And so if you've misplaced them, we'll give you another copy, but you got to pay the copying charges, which this says we can charge.
There is one part of the law that does allow an owner 8 hours of
to look at the financials
per year.
That's if it's in the management office. I mean,
Well, technically under the law, the association must have available for inspection. That's not making copies.
Right.
The minutes and the financial statements. If they have a resident manager in his office or the board treasurer's home or wherever it may be, you have to have that. What a lot of owners don't understand is if they want copies of all this, depending what they're asked for, there may be a charge.
There will be a charge,
Yeah.
more than likely,
Yeah.
unless it's recent.
Yeah, it's like something maybe in an Adobe PDF file, it's one page, someone might just send it on, but typically the kind of requests I see, I know I got an email from an owner who just copied the statute and said, I want all the association's records and listed everything in the statute since 2002. It's a big association, so we quoted him, and it would probably cost us about $1,200 to replicate that. But he was welcome to come down to the office. We would pull all the files in the office, and he could inspect them, and then maybe decide which specific documents he wanted copies of. Because there is a cost to this, and I think that 8-hour issue has always been an issue within an association. So if you have a 400-unit association, do all 400 unit owners, so if they're banding together to fight the board or whatever it may be, are they entitled to 3,200 hours of free time to
One of the biggest problems is personalities. A board member doesn't like an owner, or an owner doesn't like a board member, and things escalate. And that's where mediation and this program of evaluative mediation may turn out to be very helpful.
Yeah, it's interesting because our next week's show is going to be on dispute resolution in detail.
Good.
Because under the current statute, you have what I'm going to call basic mediation, where the mediator has to have two people at polar ends. It's hard to get them to agree.
Right.
They have this under the statute, this form of non-binding arbitration, which you get an arbitrator's award, and it has the same cost you might have in a regular arbitration. But either side can reject it, and then they have to go to litigation. There's all sorts of tests on that. But the newest program that came out, which has gotten success across the U.S. as well as it just started in Hawaii, and I've been told by those involved they've had a 100% success ratio with it. And what it is called evaluative mediation. And the first $300 is split between the parties, $150 by the owner, $150 by the association. The costs after that are paid from the Continuing Education Fund of the Real Estate Commission. And the person is usually a retired judge. And in evaluative mediation, the mediator doesn't have to be neutral. He can say to the board or to the owner, if I was a judge, I'd make you pay the legal fees, you're wrong, whatever. He can take a much more vocal discussion on what he really thinks about this debate and try to resolve and drive a resolution and a compromise and a solution to the problem.
And if there's no solution at that, the person will know what his chances are of winning in court or losing in court.
Right.
So that's a good model.
Yeah, and there's several arbitrators or mediators, evaluated mediators, been approved by the Real Estate Commission. It's a very simple process. You go down to one of the approved agencies and fill out a one-page form that you want mediation. And I would be candid with you, I've seen many boards in this process pay the whole $300 because they see it's cheaper for us to go through this process than to hire lawyers and create all of this problem for people.
I would like to maybe to make sure that nobody misunderstands that there is there are times when things are not operating well in a condo, and when that happens, there's got to be a resolution, and if we're going to keep it at the lowest level, then something like evaluative mediation is going to have to be used. Otherwise, we're going to be all going up to the legislature, because I do know that sometimes owners have points and the board is just fighting them all the way. It's what you said earlier, transparency. If the board understands the law and is transparent with owners, they'll be less likely that there'll be a long-standing problem and new laws at the legislature.
Yeah, and I agree with what you're saying about transparency. I also would say that the first effort of a owner should be go to the board before they get into this evaluation. Try to resolve it among yourselves to see if you can you can resolve it in that manner, because transparency, fairness to the owners, being held accountable for your decisions is all part of governance, and these associations have the responsibility to take care of business pursuant to their declaration of bylaws and state law.
Right, and you know, in the statute, the board is required, well, the board has a fiduciary duty. Fiduciary duty means that when they act as board members, they can't act in their own self-interest. And you hear awful stories, and I don't think that this is prevalent, but you know, you hear stories about what happens, you know, in condominiums, and you hear about the board president whose brother is a contractor and seems to get all the work in the building, and I mean, that's a clear conflict of interest.
And there is a law about conflicts of interest,
right.
too.
And you know, so you know, people and people, you know, get on boards because they think it's a popularity contest, and they don't realize that once you get on a board, you are charged with having fiduciary duty, which means you cannot act for yourself in your own self-interest. You have to act for the whole community. And then there's something called a business judgment rule, and it's in the statute. And what it says is, if you as a board member comply with the business judgment rule, and most associations have errors and omission, you know, coverage. So that means if you make a decision as a board member and somehow it's wrong, you can't get sued if you follow the business judgment rule. And what's the business judgment rule? It's really easy. It means if you don't have expertise to make a decision, you know, like if there's this plumbing contract, and you're not a plumber, and you don't understand what it costs, you know, when the engineer comes in, and they do this presentation on how they're going to do this, really, they're going to replace all the pipes in the building, and you don't understand. Then, you know, you need to raise your hand as on the board and say, you know, I don't understand. I think you need to hire somebody to come and explain to the board and be our advocate and instruct us as to the pros and cons of what this person is talking about. And that's the business judgment rule. If you don't know, you pay and you hire an expert. And you have that expert who has errors and omission, provide you with a report, and you don't have to agree with that report. If you disagree with that report, you can hire another one. But the thing is that if you don't know, you need to find somebody who does know to tell you so that you can make an informed decision. And when you sit on the board, you know, you can't act, you know, you can't just vote with the president.
Okay. I'm gonna, unfortunately, this is a very interesting discussion, but we have a whole series coming up, and our show is coming to an end. And but the whole purpose of Condo Insider is to have experts and advocates of the industry come on, talk about the many issues that our association faces. Next week, we're having dispute resolution. We're going to have how to run a better board meeting, the 7 deadly sins of a board of directors, you know, all about insurance in the condo industry. It's going to be an educational program. In addition to that, I know the Hawaii Council of Community Associations is putting together in its final form a certification program for board members that they will go to classes over 9 months, short classes on specific topics to be
Right.
certified. So anyway, we want to thank all of you for appearing or watching our show. It's on thinktechhawaii.com. It's every Thursday from 3 to 4. We welcome your suggestions on topics and making the show more interesting. And we thank Richard and Jane for being here today. And we're so happy to be a part of this program. Thank you and mahalo.